It's also uncertain what kind of housing defendant currently has. It is believed he's living with his girlfriend.
I do object for him keeping my children for me during this matter. Our children need to be with both of us during this time.
You're going to jail to do that. I will let you know. In the last 2 months, I've had 2 parents that have went to jail.
My client lives with the daughter Nevaeh, who wants to, quite frankly, remain with him.
He doesn't care.
My client is on, has a different job. She's remarried. She has a baby.
One of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home.
I had to call the police yesterday and file a complaint on Mr. Williams. He did not drop my daughter off on time. I would also like to ask really quick if it is possible for me to speak to you privately.
I already support my kids.
Okay.
I didn't ask for you guys to be in my life. I already support my kids, sir.
Court will note the appearance of Ms. Reed on behalf of plaintiff and Mr. Bartell on behalf of the intervening parties. This is before the court on the intervener's motion for show cause for failure of the plaintiff to follow the grandparenting time order of June 12, 2024. In this particular matter, the court would note in this particular case that the court had entered that order. Ms. Reed had filed for reconsideration. First, she filed to stay the order. The court denied the stay. She filed seeking to, again, get reconsideration. The court denied that. She took the matter to the Court of Appeals, and we recently had an order from the Court of Appeals dated July 19, 2024, in which the Court of Appeals granted her motion for immediate consideration and then denied the stay. As a result, that order that the court entered remains in full force and effect. It has not been changed, modified. The court will not do so until such time as we have an evidentiary hearing, which is scheduled for early August in this particular matter. Ms. Reed, what's your response to the motion?
My client is not withholding the child. The child is simply refusing to go, as we repeatedly stated. She's adamant that she does not want to see her grandparents. That's essentially what's going on, Your Honor. He's encouraging her to go. I've talked to my client. I've talked to my client about enforcement of this order and the consequences. He understands. Our appellate counsel has also talked to my client. He's encouraging this child. She does not want to go and see her grandparents.
Well, I understand, but child's 6 years old, and oftentimes court notes that children at that age don't want to do a lot of things. They don't want to eat their vegetables. They don't want to go to bed at night. They don't want to brush their teeth. All kinds of things they don't do. But as responsible parents, you have to do that. And the risk, sir, in this matter, let you know, is that you risk jail time if the child doesn't go for the parenting time. So it's up to you on what you want to do. If you want to do that, that's up to you. I can't, again, keep you from going to jail if you don't if you don't comply with the order.
Your Honor, could I add just briefly for your information?
Sure.
I just want to respond to that allegation. They have not even made the grandchild even available. She has not even been at Mr. Cronkite's residence during the times that my client has tried to even pick up the minor child. The police have been present, and there's been times Mr. Cronkite has not even been there. So it runs shallow to suggest that they are trying to comply when they're not even available and making the child available for such grandparenting time.
I understand. The court will simply enforce its orders in this matter. So again, the plaintiff will have to have the child available for that grandparenting time, which means he obviously has to be there. The child has to be ready to go when they come to pick the child up. And that's what happens. And we'll address the contempt issues at the time of the evidentiary hearing in this particular matter. Only thing I would say, and I did receive the response from Ms. Reed and Mr. Bartell. You might want to have your client note that the intervener's trial by social media is probably not appropriate in this matter. And it would probably be well not to, again, continue to do that because it only had issues in this particular matter. So we'll put it all over to that hearing, but the court will enforce its orders. And if it takes, sir, you're going to jail to do that, I will let you know. In the last 2 months, I've had 2 parents that have went to jail such time as they, until they make sure that the parenting time occurred. So I'm just cautioning you as to that. So we'll see you back in August and we'll address everything then. And hopefully, Mr. Bartel, your clients are able to get their parenting time until such time as we have that hearing. So,
Is there any makeup, I guess, in the meantime?
well, we've got to get parenting time started and then we'll address the makeup.
Okay,
Okay, Mr. Bartel, you can prepare that order.
all right, thank you.
Okay, thank you. Court will note the appearance of Ms. Henderson on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, exclusive use, and other relief. Ms. Henderson.
Good morning, Your Honor. Thank you. The parties in this case share 3 minor children. They're all very young, ages 5, 3, and 2. The parties separated on April 20th when defendant left the marital home. And since that time, he had 1 non-overnight visit with all 3 children. Plaintiff is contending that it is in the best interest of the minor children that she have temporary sole legal and sole physical custody of the minor children. And that is for the reason that relates primarily to the mental health of defendant. Lately, he has been having extreme anger outbursts. There is a current PPO in this matter, case number 2024-1284 PP, due to defendant's continued death and great harm threats to plaintiff. Defendant caused significant damage to plaintiff's car recently, where she had to replace all the car seats due to glass being in all of them. He has damaged the marital home. He recently started excessively consuming alcohol. All of those issues signify that defendant may not be suitable to provide care and custody for the minor children in his current mental state. Defendant was recently arrested on a charge for resisting a police officer in the 4th degree, and he is awaiting sentence in that matter in the district court of this county, case 2024 C246745 FT. It appears that defendant in his current mental state is not able to make sound decisions for himself. So it is reasonable to infer that he would not be able to make reasonable decisions for the minor children as well. Defendant works 3rd shift Saturday through Monday every week, and his schedule is not flexible. Plaintiff works day shift. Her schedule is very flexible and can accommodate any needs that the children may have. It's also uncertain what kind of housing defendant currently has. It is believed he is living with his girlfriend, but we actually do not know the address of that, and that would need to be provided to the court for getting proper notifications. And we're not aware if he has proper car seats or beds for the minor children, and those would be necessary for the young children. For all of those reasons, we are seeking that plaintiff be granted sole legal, sole physical custody in the temporary period of time, with giving defendant non-overnight frequent parenting time that would accommodate the children's needs for supervision and care. We would also ask for defendant to undergo a psychological evaluation to determine if there's an underlying issue that causes those anger outbursts that could absolutely put the children in harm's way and cause defendant intentionally or unintentionally to harm the minor children.
Thank you.
As it relates to child support, Your Honor, plaintiff is employed at Sunshine Toyota. She's salaried at $47,000 per year. Defendant works at Target Distribution Center. We believe his income to be $24 an hour, and he works 3rd shift. So we're not aware if there's any differential for 3rd shift. The children are insured through defendant's work. The cost of that is unknown, so we would ask that the parties exchange pay stubs for determination of proper child support. There is currently no daycare costs. Plaintiff has a lot of family members that are able to help with childcare if necessary. And we would ask for the child support to be established in accordance with the Michigan Child Support Formula. As it relates to the other relief, briefly, Your Honor, as stated, there are some anger outbursts that cause damage to the marital home. My client has been occupying that home since defendant left in April of 2024. She intends to keep that home after the divorce is final. She would assume bills associated with that marital home. If she is granted exclusive use, she would ask that she be allowed to have exclusive use of the marital home. And given the circumstances surrounding this case with the PPO and other criminal charge pending, it is appropriate for the minor children to have a stable home in the marital home of the parties with plaintiff. As we stated earlier, we're asking for defendant to undergo defendant psychological evaluation to determine if there are any issues that cause his anger outbursts and follow the recommendations of that psychological evaluations. We would ask for him to obtain proper car seats and beds prior to having any extended or overnight parenting time with the minor children, and provide the address to the court and to my client as well. Because there is a current PPO in place, if it's modified to allow child-related contact, we would ask that that contact occur through app close or a similar app for the parties' communication. So, Your Honor, we're seeking that my client be granted sole legal, sole physical custody of the minor children. Defendant be granted non-overnight parenting time.
Ms. Henderson, you don't need to reiterate. I've heard it 3 times already.
Okay, thank you. That's
Okay.
it. Thank you, Your Honor.
Mr. Kleins, what's your response?
Couple things. I didn't move out till May 23rd. And the only reason I moved out is because she had filed a PPO and was threatening to call the police on me. The broken window incident happened after I was assaulted by her and her mother. They said I only had 1 visit, 2 on 6/16 and 6/26, which I have text message proof of that. And then I also attempted to visit the kids on 6/2, 6/8, 7/3, 7/4, 7/6, and 7/18. My pay is $890 gross a week, and I pay $150 a week for insurance. And then I don't agree with the primary legal custody. I would like split legal custody, and she can have primary physical custody and exclusive use of the home.
Okay.
Your Honor, there's one more issue that we brought in our motion. We're asking for the status quo to continue as to the car loan payment and the car insurance payment as well.
Well, I'm not going to address division of property or any of those things.
Just
at
during
this
the
time.
pendency of the divorce, Your Honor, so those
Again,
payments.
I
are
just
to-
said I'm not going to address those at this time. Okay. What the court is going to do is the court will, on a temporary basis, will grant the plaintiff temporary custody. We can address the other issues as we proceed. Court will order support consistent with the support guidelines. Court would order that the parties would exchange income information within 10 days of today's date. That means providing check stubs or whatever you have, sir, to Ms. Henderson so that she has that and she can look through whatever it is. I understand you have the insurance, but she'll have to look through all of that. Court will grant plaintiff exclusive use because defendant does not dispute that she'll be responsible for the costs and expenses of the household. Court will order that, sir, what is your living arrangement such? Do you have bedrooms for the kids, beds, whatever it might be?
I do not at this point.
Okay. What the court will do is the court will grant you parenting time and alternating weekends on Saturday and Sunday from 9 o'clock a.m. to 5 o'clock p.m. each of those particular days. Yeah.
Real quick, I work Saturday, Sunday, Monday, 6 a.m. to 6 p.m.
That's right. I remember Miss Henderson mentioning that now. So it's Saturday, Sunday, Monday.
Yeah, yep, 6 p.m. to 6 a.m.
So you could exercise the parenting time from Wednesday, Thursday, Friday during those,
Yes, sir.
or for Thursday and Friday or some combination. Why don't we do that? Why don't we make it on Thursday and Friday from 9 a.m. to 5 p.m. Obviously, that's, I assume your child is 5 is going to be in school, so that we may to adjust that or something, but at least for now, he can exercise that and he can start this Thursday. The court would order that those exchanges occur. And sir, what's going to happen because of the PPO, the court will state that you will not be present during the exchanges. You'll have to have family member or somebody else that is familiar with the children that can in fact accomplish the exchanges. So you need to have proper car seats to do that.
Real quick. I know said Thursday, Friday, but I know with her schedule and who watches them, if we could do Wednesday, Thursday, that would probably work better.
I don't have a problem. Is that all right, Ms. Henderson, to do Wednesday, Thursday?
Lisa, can you confirm, please? You are on mute.
You're still muted, ma'am.
That would work perfectly.
Wednesday,
Okay.
Thursday works? Thank you.
Yes, please.
Okay, we'll do Wednesday, Thursday in alternating weeks, or that the defendant would not consume any alcohol or legal drugs during the parenting time. The court would also order that all communication in this matter would occur through Ms. Henderson's office. So, sir, if you have to communicate with, again, the plaintiff, you'll do that through Ms. Henderson's office.
Including for like the visit times and stuff, we can't use the app close app.
Do you have a problem, ma'am, with doing the app close?
No, that would work perfectly.
Your Honor,
Okay,
the only issue we have is I believe the PPO does not allow contact related to the children. So if the court would make that amendment, we have no problem.
yep, court would that, so the communication would occur through app close. I think that covers everything, and Ms. Henderson, you can prepare the order and submit under 7 days.
Your Honor, for the child exchanges, does the court wish for them to occur at the Battle Creek Police Station or any other place?
Well, if we have a third party, they can occur at the plaintiff's residence.
Okay,
Because it'll be a third party, not the defendant.
Is it okay if she drops them off at my parents' house?
Or your parents would have to pick up the kids, whatever the
Yeah.
case be.
Yeah.
Because you have the responsibility for the transportation, notwithstanding the fact that you can't do it yourself.
Yep.
Okay. That will be the order. Ms. Henderson, you can prepare the order.
thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Thank you.
You too. Thank you.
Court will note the appearance of Mr. Schaefer on behalf of the defendant. This matter is before the court on the plaintiff's objection to the proposed order. That would be the ex parte order entered on July 1, 2024, placing the children in the temporary care of the defendant pending the CPS investigation. Ms. Newby, you can proceed.
I do object for him keeping my children for me during this matter. Our children need to be with both of us during this time. I wrote a letter here. I don't know if I need to read everything that is on here from my objection that is placed in front of you, but I do feel as if our children are being put through so much more emotional stress and being kept apart from myself and them. This is the longest we've been away from each other. I know without a doubt that this is not in the best interest of our children, let alone our daughters who need to be with their mom and have expressed this. Our children should not be being kept from me. I believe I'm falsely being portrayed as an unsafe parent to our children, when there is zero evidence that I am or ever have been an unsafe parent. I have agreed to and signed the safety plan that the CPS caseworker provided me, and the safety plan states that Audrey and Bailey have zero contact with Adam Lafferty and that we have no communication about Adam. I have yet to been able to follow this plan, Your Honor, or prove that I can follow this plan. I have my own apartment here. I have a full-time job. I'm doing everything I can to prove that I'm a stable parent for my children, and I feel like I'm being portrayed that I am not.
Okay, thank you. Mr. Schaefer, your response.
Well, the situation is kind of the same as it was at the ex parte order, that these twins had relayed some inappropriate touching to not only their father, but to their mother also. And she admits in her objection that she was told that the boyfriend was rubbing the belly below an area that was appropriate, that the boyfriend had touched the crease by her leg. That to me is inappropriate. And my understanding that the CPS investigation is still ongoing, and there's a criminal investigation ongoing, and it has not been completed. So I think the situation is still the same, and for the well-being of the children, I think the order ought to be continued. My client, I think, has been communicating with the mother of the children to keep her advised as to their activities and so forth. But at the moment, I think the order ought to be continued.
Well, the court does note that these were very serious allegations made by the girls, and the main concern of the court is the protection of the children. And there was sufficient information that while in plaintiff's care, they were at risk of physical, mental, or emotional danger. And court notes that CPS and as well as police have a criminal investigation in this particular matter. What I will do is state that there may be some provision or whatever. Newbie, if you contact Mr. Schaefer, maybe you could make some arrangements where you'd be able to have contact with the children outside of the home or something of that nature, some sort of a limited parenting time. So I will leave that up to you. If not, you can always file a motion for parenting time, but I don't believe that it's appropriate to, again, vacate that order at this time. So the court will continue the order and deny your objection at this time with the, I guess, the recommendation that you contact Mr. Schaefer and try to arrange some sort of time where you can have contact with the children. Okay, that will be all we'll do today. And Mr. Schaefer, you can do an order denying the objection.
Well, Ms. Newby, give my office a call. We'll see what we can work out.
Am I not allowed to say anything further?
No, okay, the hearing's done now at this point.
Okay,
Thank you.
thank you.
Court will note the appearance of Ms. Moss on behalf of plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and exclusive use. Court will note that it is now 10:31 a.m. The matter was set for 10 o'clock a.m. and it has not appeared, nor has the defendant filed a responsive pleading. As a result, the court will grant the plaintiff's motion in this matter. Court will grant plaintiff temporary custody. Court will order parenting time at all times and places the parties may mutually agree. Court will grant support pursuant to the child support guidelines. Will grant plaintiff exclusive use of the marital residence, responsible for the costs and expenses of maintaining that home. Court will order that the defendant will have a third party provide transportation to facilitate any parenting time agreed to between the parties. And the court, to clarify my point on the exclusive use of Ms. Moss, I had a note further says here, plaintiffs will pay 1/2 of the mortgage payments on the property. And the court will, on the 1/2 to be paid by defendant, the court will deduct that from his gross income for purposes of determining the net for support purposes. Ms. Moss, anything else?
That's it, Your Honor. Thank you.
Ms. Moss, you can prepare that order and submit under 7-day notice.
I will. Thank you, Your Honor.
I'll get that out of the way. Court will note the appearance of Ms. Redmond on behalf of the plaintiff, Mr. Vanderhorst on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary support, custody, and parenting time. Ms. Redmond.
Good morning, Your Honor.
Good morning.
As a preliminary matter, there was originally a motion for genetic testing for this morning on the docket. However, all parties have stipulated and an order has been sent out for signatures and will be submitted and filed with the court later today.
Okay, go ahead.
And second, and Mr. Vanderhorst can speak to this as well, but we're currently scheduling mediation for this matter. And I believe we're tentatively scheduled for August 13th with Gale Town. And plaintiff today is requesting that the parties are awarded temporary joint physical and joint legal custody of Nevaeh, the minor child. Nevaeh was in plaintiff's sole care from about February of 2023 until August of 2023. And then defendant began exercising supervised parenting time. From November until April of this year, defendant exercised non-overnight parenting time. And then in April, there were 2 occasions in which defendant did not return Nevaeh to plaintiff at the agreed time. And since then, Nevaeh has been spending about 3 to 4 overnights per week with defendant from that time on. Plaintiff is requesting that they return to the stable schedule for the minor child, that the parties are awarded week on, week off parenting time for the duration of the summer vacation of Nevaeh, with exchanges happening on Friday, and then weekdays with plaintiff and weekends with defendant once school starts, to reflect the original schedule from before April, as well as any additional parenting time as the parties agree, and requesting child support as according to the formula. And that whichever parent is exercising parenting time is responsible for transportation. Thank you.
Okay, thank you. Mr. Vanderhorst, I think your answer has that reverse. It has your client having, or no,
Yeah.
as your client having the child Friday or Monday through Friday and plaintiff on Friday through Monday. Is that correct?
That's correct, Your Honors. The parties have about a 13-year marriage. They have a daughter who's going to be 13 in a couple of weeks, Nevaeh. She has lived primarily with my client since about April, 1st of April of this year. The parties separated last year. The plaintiff mother lives with the biological. She had a baby in April, a 2-year-old baby or 2-month-old. She's going to be 3 months old in a couple of weeks. The current living conditions in the former marital home is the plaintiff mother, her mother of the child. The child was just born as an infant. And then she has 2 older children as well. So it's a busy house, busy place. Plus the new as well, that is not my client's. My client lives with the daughter Nevaeh, who wants to, quite frankly, to remain with him in his home. She's been there since April. She finished out the school year there. And my client would like to keep that arrangement because it's working very well. He can get the child to and from school. He did last year. She's doing very well. She goes to Battle Creek Christian Academy. He pays for the tuition, which is $400 per month. He solely pays for that. The reason it's $400 is because there's an offset, kind of an add to payments that were made before, so he's paying the full thing. I think otherwise it's typically $200 per month. Correct. But he's paying $400 a month to catch up. He does provide medical insurance for the minor child as well, and himself. And so what he would like to do, and what quite frankly the daughter would like to do, is continue the schedule, continue going forward. He would have Monday through Thursday or Friday morning. He does take the child to school. He does pick up the child after school. He's got a flexible schedule at work. And we believe the mother works at 5 in the morning till 5 in the afternoon. I don't know if she's still on maternity leave or what. We don't really know what's going on over there. But we'd like to maintain that schedule. That's what they've been doing for about 4 months now, Your Honor.
Okay.
To continue that.
Okay.
So that's really in a nutshell.
Okay, thank you. Well, in this matter, what the court will do is the court will, again, the parties are not disputing that they have joint legal and joint physical custody. They're just really arguing about parenting time. The court would obviously allow the parenting time to occur in the summer in alternating weeks from Friday at 6:00 p.m. to the following Friday at 6:00 p.m. In the summer, court would have alternating holidays as well. The court on a temporary basis would order that the defendant would have the parenting time Monday at 8:00 a.m. through Friday at 5:00 p.m. And then the defendant would have the child from Friday at 5:00 p.m. to Monday morning at 8:00 a.m. The court would have support set consistent with the support guidelines. And each of the parties would disclose their respective incomes through the attorneys within 10 days of today's date. So we can calculate that. And we'll ask Ms. Redmond that she would prepare that order and submit under 7-day notice.
Yes, Your Honor. Thank you.
Thank you.
Your Honor, just for clarification, is that they're maintaining basically the schedule they're doing now?
Excuse me?
Is that what I heard? Would my client have the Monday through Friday?
Yes.
The defendant?
Yes.
Okay.
Yep. AM to 5:00 p.m. on Friday.
Very good, Your Honor.
Okay.
1 second, Your Honor, that doesn't mess up next week's.
What?
At all, does it?
No,
No,
because
okay.
next week is Monday through Friday.
Yep. Very good, Your Honor.
Okay, thank you.
Thank you.
Thank you.
It doesn't care.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion to modify support with regard to child care expense. Ms. McNiff.
Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. This is really a pretty simple motion. Right now, the parties are required to each pay 50% of any childcare expenses. That was an agreement that they reached in their original judgment of divorce. Since that agreement was reached, my client is on has a different job. She's remarried. She has a baby. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of there not being sufficient PTO to get sufficient sick time. She at one point was taking care of the children when they had COVID during Mr. Gentry's parenting time. The kids have had some significant medical issues, some like tube surgery, things like that, that she's had to take time off for, and she simply couldn't do it with the previous job. So she took a remote job so that she could meet those obligations. We've also been in court a lot, which was a difficulty for her and with her previous job. So we're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan childcare formulation that would assign the parties. We do have this matter currently in front of referee Snyder on a change of domicile request, change of custody, change of parenting time. However, this particular part of the child support formula was not an issue, and I think in order to get it there, either the court needs to rule on it or send it to referee Snyder.
Okay, thank you. Ms. Thomas, any response?
I do, Your Honor. I don't think it's as simple as what Ms. McNiff purports it to be. Our answer to the plaintiff's motion certainly sets forth the defendant's position regarding the 50-50 childcare. However, I would add that to clarify, I just want to clarify a couple of things. First, at the time of filing our answer, this motion hearing was scheduled for last week. So we had said there was 9 days before we'd be in front of court again. We're actually in front of Mr. Snyder again on Wednesday of this week. And so there's no reason that this motion couldn't have been brought at that hearing. This is just an extra motion for no particularly good reason other than it cost Mr. Gentry a lot of money. But more to the point, the parties negotiated. And they reached, it was by the judgment of divorce was entered by consent. And part of their negotiation was that because Mr. Gentry for a while was working at home, because that was part of what his job was doing, that's not the case anymore. And there was some variables, but the parties agreed that it should be 50-50. And that's what they agreed to that. And that's part of the other issues in the case settled because of that. So therefore, that was a negotiated agreement and it wasn't part of it. And if you look at the uniform child support order, you know, it's purported that it's in there. It's not in there. And if you look at the formula that's attached, the calculations attached, it's not on there. It does not say that at all because the parties had agreed that it was going to be 50-50. If it was summer, if it was before and after school, whatever it was going to be 50-50 because that was part of the settlement that they reached based upon all the totality of the circumstances of their particular case. For clarification, in plaintiff's motion regarding change of domicile, she specifically requested relief as it relates to childcare in this matter. And Mr. Snyder has in fact heard testimony as it relates to the issue of childcare. In plaintiff's motion regarding change of domicile legal residence, although she indicates that she's also asked for custody and parenting time, in her motion, that's not true. In her motion, she acknowledged childcare expenses for the children under the age of 12 are to be paid 50-50 and specifically requested reimbursement regarding questionable childcare expenses. So this issue of childcare between these parties is already in front of Mr. Snyder and he's already heard testimony. So to have yet another motion that we can again prepare for yet another motion, another thing is ridiculous. And also, frankly, one of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home. And it was at a state farm agency and it was contingent upon her being able to move there. And then she quit her job at State Farm here. And that was all as a furtherance of her career. That was one of the big things reason that she, was going to do this. And now she quit her job. She worked at another job. She worked full time. She said she was going to only work part time. There's been like, it was this and it's like, and the testimony and the actions don't match. And she was going to have, and specifically, I believe that she said that plaintiff alleged in her motion that her fiance is, quote, supportive of a part-time work arrangement for her. His career is stable and he is well compensated, which will enable a more relaxed professional schedule for me. Yet she quit her regular job. She took a full-time independent contractor job, if you will, with no benefits. And then now and because of this the financial affordability, because of her fiance's and now husband's income. And now here we are. We already agreed on this. This is something that they negotiated before Lisa was involved, before Ms. McNiff was involved, before I was involved. And now here we are saying, oh, well, wait a minute, that's not affordable now. I mean, I think she used her new financial windfall and she needs to suck it up. That was their agreement. This is, again, 1/2 share of childcare expenses is what they agreed to. And it's not included in the uniform child support order. This issue with regard to who's going to pay what for last summer is before referee Snyder. So this issue was already in front of him. And this, again, another motion that the plaintiff has brought that we have to prepare for, get ready for. And we're just asking that the court uphold the current order of the court, the judgment of divorce, which is the court order by consent of the parties. Although Ms. Gentry indicated that she has paid her 50% of childcare. She has not. She's not paid anything this summer at all. And now we have attorney fees in addition. And it's the same subject matter that's already before Mr. Snyder, that he's already taken testimony as to these issues, in fact.
Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in childcare costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issue. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7-day.
Your Honor, will the court consider our request for attorney fees?
I'm not going to at this time.
Okay, thank you.
Court will note the appearance of Mr. Umloff in this matter. On behalf of the defendant, this matter is before the court on the defendant's motion for supervised parenting time. Effectively, a court does note that there was an amended order for counseling and attorney fees back in September of 2022. Apparently, that counselor, Rebecca Walker, has recommended supervised parenting time with Frank Lewis of Kalamazoo Psychological and alternating weeks. Is that the substance of your motion, Mr. Umloff?
Yes, it is, Your Honor. We also request that the plaintiff participate in the reunification counseling sessions that Mr. Johnson is having with the minor child at the discretion of Rebecca Walker, the counselor.
Okay. Ms. Gray, what's your response?
My response is it really just depends on what time it's supposed to be at, because my work schedule is 8:30 a.m. to 5 p.m. and as it is, the reunification counseling sessions were already, like, she already changed her schedule around so that she could fit them in at a later time so my stepdad can get her there.
Okay, well, those are always difficult with the counselors and what they can work. Obviously, they attempt to accommodate those. All I could say in this matter for counseling, Gray, is if you're not available, you have to arrange to have somebody that is available to maybe transport the child for those particular counseling sessions. I have no idea what both of your schedules are or how that's going to coordinate or how it's going to coordinate with the counselor. So the court would order the continuation of the counseling with Ms. Walker, and also that there be supervised parenting time, a reunification counseling with Mr. Frank Lewis of Kalamazoo Psychology in alternating weeks at a time that the counselor can arrange that and attempt to accommodate the party schedules. Mr. Umloff, you can prepare an order and submit under 7-day, which would then reflect that.
Your Honor, what about the request that the plaintiff participate in my client's reunification counseling sessions with Rebecca Walker at Rebecca's discretion?
I said that the parties would participate in reunification counseling, so,
My apologies, I misheard you.
yep.
Thank
Okay,
you, Your Honor.
Ms. Gray, you'll get an order probably within a week and a half that reflects all that, and then you'll have to coordinate it with the counselors, with Mr. Lewis and Ms. Walker as well. So you're free to go. Have a good day.
Your Honor.
Court will note that both parties in this matter are appearing in pro per. The plaintiff has filed a motion to set aside referee recommendation in which she states, and I quote, "I respectfully feel that as though the referee did not take any of my complaints or worries into consideration," end quote. Anything else, Ms. Moore, as it relates to your objection?
Yes, sir. I would also like to ask really quick if it is possible for me to speak to you privately.
No, absolutely not. The court does not have ex parte communication with any one party.
Okay, understandable. Well, I would like to state that I had to call the police yesterday and file a complaint on Mr. Williams. He did not drop my daughter off on time per, the court papers.
Okay, ma'am, if that happened yesterday and he did not comply with the orders, you have a right to file a motion seeking to show cause why he shouldn't be held in contempt for not complying with the orders, but that's not before the court today. It's simply your motion to set aside the referee order.
Okay, so I would have to file a motion to
Have him held in contempt for violating the court order. And that's separate from this because that's not what we're here for. And the court will tell you just because the referee did not rule in your favor is not evidence that the referee made a factual or legal error. The court cannot set aside the referee order unless they made a factual or legal error. And simply, as you stated, that you don't believe that your complaints or worries were taken into consideration is not a factual or legal error. So I need to know what that might be. And if so, then we can look at that.
I tried to explain to the referee that he had left my child at home by herself. She has called me crying. Like, I tried to make all these complaints to the referee. Like, I wrote the letters that I was told to and made my complaints, and I don't feel like.
Clarify, ma'am. When you write letters don't mean anything. That's not evidence. You have to bring in witnesses. You have to bring in evidence to court. If you wrote a letter, for instance, to the defendant, you could bring that in and submit it as an exhibit, and then it would be evidence. But simply writing letters to nebulous entities isn't evidence. So you have to present it at the hearing. And in this case, the referee saying you didn't do that. And therefore, that's why he dismissed your motion.
Okay, well, I would like to request an adjournment. That way I can seek legal counsel.
Well, I'm not going to adjourn this matter. I'm denying the motion. You have not submitted that. We're not going to let it drag on. If you have a basis to proceed on something else, you can get an attorney, you can file a motion. But again, this is the time and place set for you to establish your case, and you haven't done so. So I'm denying your.
I just had to call the police on him yesterday.
I'm denying your motion, ma'am. You have to file a motion on that action. That's not before the court. You can't come to a hearing. You can't come to a hearing, then bring up all sorts of other things that aren't in your motion. Okay. The other side, in this case, the defendant has a due process right to know why he's coming to court. And you can't come to court and say, okay, I want to address support. And then when you come to court, I want to address parenting time and custody and all sorts of other things. You can't do that. You've got to have a proper motion, and then the court can address it. So I'm denying the motion at this time. You don't need to do anything, sir. You're free to go. Have a good day. Court will note the appearance of Ms. Reed on behalf of defendant. This matter is before the court on the defendant's motion for psychological assessment, counseling, and modification of child support. I've read that. The court will note that it is now 9:22 a.m. The matter was set for 9 o'clock. The plaintiff has not appeared, nor has the plaintiff defended in this matter. So the court will grant your requested relief, Ms. Reed, and allow you to get a psychological assessment with Dr. Haugen or somebody, other individual in his office qualified to do so. The court will order counseling with Sandra Burdick in this matter in order that the parties would each pay 1/2 the cost of the counseling. And the court would recalculate child support with the defendant having income for 32 hours at $22.93 per hour. And the court would order that the plaintiff would disclose her current income, in this case, no later than 14 days from today's date. And I'm giving her that time, Ms. Reed, only so that, you know, under 7-day notice, it'll take time to get, so if I did it in 7 days, she probably wouldn't get it before she had to comply, so.
That's correct.
Okay. You can prepare that order and submit under 7-day notice.
Thank you.
Thank you.
Thank you. I understand the moms are in situations, but that's not my problem. We're not together anymore. It's all about my kid. If you want extra money, then go get a job or better your education. You know what I mean? Like, I'm doing what I have to do for me to make sure that I'm okay. And to make sure that when my kids come to my house, I'm not lacking something. I'm not missing something. If they want to go do something, hey, let's go do this. Dad, I want Tony, my daughter, 12-year-old. Dude, every time I take her anywhere to go eat, it's, Dad, I want a whole full rack of ribs. Guess who has to pay for it? It's not my wife or my girlfriend. I'm not married, but it's not her. I'm the one paying for that. I got to take her out. But like I said, I just got a chance to start seeing my daughter in November because her mom kept her away from me for 5.5 years. So, I mean, that's the type of stuff that I'm dealing with versus just being me, man. Just trying to live my life and do what I got to do for me, you know?
All right. Is there anything else you would like to tell the court?
I don't know what else there is to say, sir. I am a responsible enough parent where I don't need child support. I don't know what else to say. I don't need this. And I don't know why I'm paying back somebody else's financial issue. This isn't my financial issue. And when my kids need me, I'm there. You know, when they call me and, Dad, I need this. All right, sweet.
All right, thank you. I have no further questions.
All right.
McClure, in this matter, the support orders in place, and those support orders order you to pay a particular amount to support your children. So that's why you're having to pay, is to support the children when they're not with you, but with the other parent. So do you work at Airway?
Work at Airway, or you guys will be still getting a check from Airway.
Well, that's what I asked, because you talked about being at Airway and you'd have people come to Airway. So I wasn't clear if you were working there or not working there.
Well, this is where I set up my truck at. I tell you what, I'll because I'm still on Wi-Fi, I'll let you see what I use.
You don't have to. You don't have to.
Just
see.
look, no. Just look. No, sir. This is what I drive. That's my vehicle right there. That's all I have. I don't have a building. All I have is a house.
Okay.
That's all I drive. So I don't have a brick and mortar. I don't have all that stuff.
Okay. In this matter, if in fact, as you've talked, that your employment is sporadic, that you, as you said, it's good in March and April, and then November and December, why don't you get a full-time job that'll pay you each and every week?
Because I still get people to trickle in that get tires done at different times of the day. So if I have a job, how am I supposed to cover that part of it? If they need a tire done.
You have time to do that, but you'll have a full-time job that'll pay you far more than $150 per week.
But I like what I'm doing, sir. That's the difference. I actually like what I'm doing. You know, I've chose other jobs. I've done the factory work. That's not for me. I talk too much. I've gotten fired from that. Dude, I was an electrician. I got fired from being an electrician because I talk too much. I talk too much. I can't be in nobody else's job. I have to do my own thing and be my own person. I can't do another job. I can't. I've tried it. I've never kept a job longer than 2.5 years. And Airway was the only place I stayed longer, only because they left me in the corner and let me do tires all day long. That's why, that's the other. I worked at McLean's Towing. When I worked at McLean's Towing in 2015, I was like, well, why would they keep dropping cars off at Discount and Bell when they could just put something like this together? So that's what I was actually expecting is to actually get picked up by some of the tow companies and talk to Buds. I know Robert at Buds. I've talked to Patty and Kevin up there at McLean's. Nobody's picked me up yet because I know how that operation works. I know that you got to be, their insurance companies have to pick you up and say, hey, you know, we trusted this guy. And I'm a legal LLC business. Still never picked me up. So that's, I kind of like what I'm doing because I don't have to, if I want to talk too much, that's fine. I'm not going to get fired for talking too much. And I can't help it because I'm ADHD, so I talk too much, I thought. So everything sometimes comes out of my mouth. I get in trouble.
Okay. Anything else you'd like to tell me, sir?
I don't know what else to tell you, sir.
And anything else, Mr. Sacred?
No, Your Honor.
Well, in this matter, the court's heard the testimony that Mr. McClure has a support obligation in the one case of $549.50 and the other $48.50 per month. That in fact he has a sizable arrearage on the 2013 case, and I'll just shy of $8,000. The other one is only about $650. That he has stated in this matter that he's self-employed. He against mounts and balances tires. That he has tried other employment. He was an electrician. That he had worked in factories as well. That he did not like that. That he liked doing the employment that was sporadic, where he would be busy in March or April and November and December, but not the other times of the year other than sporadically. And as a result, he has not made money sufficient to pay his support obligation, although he has made, as he states, approximately $150 per week, but he is not paid regularly, nor has he paid the support obligation that he has. The court will find that he's failed to exercise good faith attempt at compliance. He's failed to refuse to comply, and therefore he is in contempt of court. Anything before sentencing, Mr. Sacred?
Yes, Your Honor. Thank you. I would ask that the court not impose a jail sentence today. Mr. McClure has testified that he is working. He is aware of the child support obligation, and so that he can begin his continue his apologies and make monthly payments. Inclined to impose a jail sentence, I would ask the court put in place a $100 purge amount. Thank you.
Thank you. In this case, you have previously been held in contempt and received a 7-day suspended sentence. The court could sentence you up to 90 days. I'm not going to do that, but I do believe that some jail time is warranted. I'm going to sentence you to 30 days in jail with credit for no time served. Court will order that you report to the sheriff department on July 12, 2024, no later than 4:00 p.m. in this matter. The court will allow you to purge yourself of contempt on the 2013 case by paying the sum of $500, and on the other case to purge yourself of contempt by paying the sum of $200. If you pay those amounts, then you would not have to appear in jail. Otherwise, you will need to appear on the July 12 date. Any questions, sir?
Yes. Why am I going to jail for some? Look, no, we're going to be real. Sir, look, I didn't ask for the women to custodial. I guess they
Sir, no.
You're trying to take out that loan. Send me paperwork, my name on it, where I am viable for that loan. That I signed, where I signed for the money. Send me it.
Support order.
I already support my kids.
Okay.
I didn't ask for you guys to be in my life. I already support my kids, sir. I didn't ask for child support. I did not ask for child support. The moms did, sir. I did not ask for child support. The moms did, sir. I don't understand.
Sir, you're muted, so you can stop talking. I'm going to tell you, report to jail on July 12th, or we'll have you back into court and you'll be in contempt and you can serve up to 90 days. And I have no problem with imposing the 90-day if you don't show. So report no later than 4:00 p.m. on July 12th, 2024. We'll conclude the hearing. You're free to go.
1 second. I changed some settings so he will not be able to unmute himself.
Okay, thank you, Ms. Gilman. And Mr. Sackrider, thank you for your service, and you have a wonderful day and a wonderful holiday.
You as well.
Parties are both appearing in this matter in pro per. The defendant has filed a motion in regard to support. He states in the motion that support should be modified as the parties do have an equal parenting time agreement. I'll ask Ms. Moore, is that correct?
Yes, I let the child go with him when asked.
That's not what I'm asking. I'm asking, is there an equal parenting time agreement where the defendant will have a child 50% of the time?
Yes, yes.
Okay. Is there public assistance involved in this case in any way through Medicaid, housing assistance?
No, no.
Okay, sir, that's your understanding as well? There's no public assistance?
I did not know that. I thought that at least I was paying insurance on top of that.
Okay, that didn't answer my question. I asked if there was public assistance involved that you were aware of.
What is public assistance?
Public assistance is food stamps, a Medicaid, housing allowance, anything that comes from the government.
Oh, I mean, not for me.
Okay, that's what I'm asking you.
No, not for me. No, I don't have anything. No, sir. No.
Okay. Plaintiff has stated she did not either. As a result, the court will grant your motion, sir, where you can recalculate support based upon an equal parenting time schedule. So you take your income, the plaintiff's income, put it into the support calculation in the formula, and you will come up with a support amount. You can reflect that in an order for child support. And I don't know what it's going to do because I'm not whatever your income is or anything of that nature. And then what you'll have to do is submit that to the front of the court for their approval. They will then check to see if there is any public assistance involved, and just to clarify whether there is or is not. So, and sir, if you can't do that, you can get on michiganlegalhelp.org, and they have all the calculation and the formulas for calculating support and to do the orders as well.
Okay. I can't ask for joint custody in this one.
No, you asked change in child support.
I really wanted it to change to 0.
No, that's not the way it works.
Well, but at the end of the day, sir, you asked me to get a better job, right? And I can't because I got the whole city depending on me at this point in time. And it's been hard for me to make money. And
not going to get into that. What this is you did with regard to support, of course, grant your motion. You can do the support based upon equal parenting time, 182 and a half overnights. And then you would reflect that in the order to be entered.
Okay, I see what you're saying. Yes, sir. I do understand you now. I'm sorry. I apologize, Your Honor. I apologize.
Okay.
I'm sorry.
Yep, submit that and if you submit it within 7 days, you can submit it under 7-day notice of entry. If you don't submit it within 7 days, you have to motion the matter back before the court in this case. So that's up to you on what you do, but you're going to have to do it right away then.
All right. I was going to ask Joni on the other hand, sir. I'm asking her, is there a way that we can remove arrearages so that way I can
I'm not dealing with that today, sir. You only filed the motion as it related to support. If there's anything else
I thought that was part of it.
If there's, well, it's not with regard to calculation of support. You're going to have to talk to her, and if so, you can always enter a stipulated order, which would waive the arrearages if she's willing to do that. So, but that's not the court today. So,
all right.
Okay. Thank you.
Yes,
you're
sir.
free to go. Have a good day.
Thank you, sir. You too. Have a good day.
Are you able to see the children right now?
No, ma'am. She currently is failing to obey the previous court order. She has kept children from me per the previous court order.